Member for Fox Hill, you rise. Very well.
Privilege to draw a matter to your attention, please, if I might briefly, with the leave of the...
Very well. Chair recognizes honourable member for Fox Hill. Point of privilege.
Yes, as this is the most convenient time. This morning, Mr. Speaker, I read in the press, and I wish to draw to your attention, a statement by Fred Smith, QC, in which he indicates that one of our members who made a statement in the House of Assembly last week is to be brought, he says, before a disciplinary tribunal of the Bar Association on the basis of statements made in this place. Since the decision of the Justice last week, I gather that the judgment is some 95 pages. It's just been made available to us, and some of us have been reading it, and the lawyers have been studying it. And I just say parenthetically that I have a friend named Mickey Turner, who is a lawyer, who said that anytime you see a long judgment, you can bet that there's an error of law on every page. So I just start with that. But the more serious point, Mr. Speaker, is this. The nature abhors a vacuum. There's been a lot of public discussion, most of it managed by the press that appears to be hostile to the position which has been taken by members of Parliament in defense of freedom of speech in this place. And I say nature abhors a vacuum in this context, that I find that in this present dispensation, if you don't supply an answer to these contrary comments that are being made, people adopt the negative story. I think, therefore, it is important for yourself as Speaker to constantly reaffirm the point on behalf of this House, that this matter is not about saving the financial services sector or violating something in email. This is about the right of members of Parliament to speak freely in this Parliament. The law has always been clear to this point, and anyone who reads the Constitution and reads the statute law can see quite plainly on its face that anything which is said in this Parliament has no sanction, whether criminal or civil. In fact, in a backhanded way, Fred Smith QC paid a tribute and acceptance to that fact in the very statement he made today. In fact, he said he dared the Member of Parliament for
Marco City.
He dared him to come outside and repeat what he said. Well,
there you go.
If the law doesn't protect his freedom of speech in here, why is he saying that he must come outside and repeat it? That is the point that we make. And we keep saying that this is not some privilege which attaches to us personally. This is a privilege for members of Parliament to allow them to speak on behalf of their constituents. It's a privilege for the constituents, not for us. That's what it's meant to do, so that every constituent who votes for one of us knows that we, if they bring some case to us, that we can bring the case in here, and that there is no sanction, whether criminal or civil, for what we say. For what we say. Imagine, sir, that some private citizen discovered what we discovered, and the burden is then put on them to bring a legal action by originating summons. You know the prices Fred Smith charges to go to court? Can you imagine if some small private citizen in Fox Hill had to bring the matter which violated, which threatens, we say, which looks on the face of it, which threatens the stability of our country, where rich foreigners put millions of dollars through a law firm to destabilize the country, to bring that action in the courts? How much that would cost? That's why we have the privilege. It's the cheap method. They can come to us and say, we have discovered something wrong, and we think you need to go to Parliament and make this complaint on our behalf. And now you have rich foreigners using millions of dollars funneled through a law firm to actually get a judge in a court to agree to do that? And we mustn't say anything in response to that? And then you have these great intellectual lights like Candia Dames on the radio talking about we shouldn't be doing it? This is certainly wrong.
They bring emails every week.
This is certainly wrong. So, Mr. Speaker, the point I want to make again is that this is a very serious matter. This is a very serious matter which goes to the fundaments of our democracy, the right of members of Parliament to speak freely in Parliament. I say again, the matter should be dealt with dispatch through the courts. At the same time, there ought to be parallel actions in this place through the Committee on Privileges to deal with Parliament and the privileges which has and defend our position. I say also that the law is available to us through the Constitution. The Constitution says that Parliament may by law define the extent of its privileges. And the Member of Parliament for Marathon made the point that surely anything which is said in this direction is unenforceable. Because when the Constitution gives Parliament that authority and power...
Just continue on, remember.
Continue
on, remember.
What do we do? What do we do?
Continue on, remember.
You know? Lord have mercy. Lord have mercy. Lord have mercy. Christ have mercy. Lord have mercy.
Continue on, remember. Just continue to address the chair.
So what I'm saying is Parliament has this privilege. And what I'm saying is that because it has that right, Parliament at the end of the day could define the privilege to vacate the very judgment which exists. It has that power, and that's a constitutional power. It's not something which we take unto ourselves. It's a power which is in the Constitution. And so I'd like to fill that empty space and go contrary to this nonsense which is being spun out there on this point of privilege. And I commend my statement again to the Committee on Privileges. Thank you, Mr. Speaker.